Good morning, friends. In this video, I will talk about provisions regarding minors or the persons who are not able to defend due to their mental conditions. I am talking about Order 7, wherein the total provisions are provided how to handle a case when the minor or person of unsound mind is involved. So, friends, I am going into brief about that order, which contains 13 rules. Firstly, institution of proceeding. Every appeal, petition, or proceeding by a minor must be instituted or continued in minor's name by a next friend. Friends, you will ask about who is minor. That is defined in the Indian Majority Act 1875. Then comes the role and retirement of next friend or guardian. The next friend or guardian cannot retire without the court's permission. The court may require a suitable replacement and may demand security for costs before allowing retirement. If the next friend retires or is removed or dies, further proceedings shall be stayed until a new next friend is appointed. If the advocate on record does not take timely steps, any interested person may apply for the appointment of a new next friend. Now, coming to appointment of guardian for minor respondents also. There may be a respondent who is also a minor. So in that situation, if the minor respondent lacks guardian, an appellant, petitioner, or interested person must apply for one. The proposed guardian must have no conflicting interests, and if not a natural guardian, such as father or mother, prior notice must be served. If no suitable guardian is available, the court may appoint an officer of the court as a guardian. Now, removal or substitution of guardian. A guardian cannot withdraw from a suit, appeal, or proceeding without the court's permission. If the guardian fails in duty or there is sufficient cause, the court may remove them and pass appropriate cost orders. If the guardian retires, dies, or moved, the court must appoint a new guardian. Now, let us talk about financial assistance for guardian ad litem. If a guardian ad litem lacks sufficient funds to conduct an appeal or petition, and the minor's defense may be prejudiced, the court may order the appellant or petitioner to advance necessary funds. These amounts will be considered part of the appellant's or petitioner's cost. The guardian must file an account of the funds received in court. Sometimes there happens agreements, compromise, or withdrawals. Then a next friend or guardian cannot enter into an agreement or compromise on behalf of a minor without the court's express permission. An application for leave to compromise or withdraw an appeal must be supported by an affidavit stating that the compromise benefits the minor. If the minor is represented by an advocate, a certificate or statement from the advocate affirming the benefits of the compromise is required. Any decree or order based on such a compromise must include the court's sanction and the terms of the compromise. Setting aside decrees against minors. A decree against a minor will not be set aside merely because the guardian had an adverse interest unless such confliction resulted in prejudice to the minor. The minor may seek relief under the law if the guardian misconduct or gross negligence caused him harm. Sometimes what happens, the minor becomes major during the trial of the courts. So there is declaration of majority. An application to declare a minor as a major and discharge their guardian must be supported by an affidavit stating the minor's age and date of attaining majority. Notice of application must be given to the next friend or guardian and the alleged major. Now, when there is unsound mind or person of unsound mind, these provisions apply mutatis mutandis to persons adjourned of unsound mind or found incapable of protecting their interests due to mental infirmity. Friends, rules of order 32 of the Civil Procedure Code shall apply to appeal and other proceeding with necessary modification. Friends, there was some mistake in pronunciation, so please take care and enjoy this video. That's all. God bless you all.